SJC-12019, Massachusetts Insurers Insolvency Fund v. Berkshire Bank.
Good morning, Mr. Deshane.
Good morning. May it please the Court. My name is Greg Deshane, and I represent the Massachusetts Insurers Insolvency Fund. The question before this Court today in this case is whether the high net worth insured provisions of Chapter 175D, which is the Guarantee Funds Enabling Statute, whether those provisions apply to claims under workers' compensation policies. It's a question of statutory construction. I don't believe there are any disputed issues of fact. In 2006, the Massachusetts legislature joined 34 other states that had passed similar net worth provisions and adopted a high net worth provision.
Can I ask you, you're saying it was on the model, it was the Model Act, right?
Yes, it was based on the NEIC Model Act. That is correct,
So those
Justice
34
Sloan.
states, did they have a workers' compensation scheme like ours?
Different jurisdictions obviously have different
Does any of them have
workers'
anything
compensation
like ours?
schemes.
Do any of the 34 have anything like ours?
I am not aware of whether they're exactly like the Massachusetts system, Your Honor.
Okay. And you know the respect in which I'm asking that it's alike, which is that the insurer has direct liability.
Yes, and I do intend to
Okay.
address that issue in my argument as to why that doesn't make any difference in this particular case. As we said in our briefs, under, I think you're referring to whether a claim is paid on behalf of the insured under Section 17(3), whether there has to be a continuing obligation on behalf of the employer to pay the claim. And it is our contention that that does not matter, that the Superior Court misframed the issue, looked at it through the wrong prism, and was asking the wrong question there. Because it is our contention, and this is the technical argument, under how Section 17(3), the language, which is not defined, pay on behalf of, it's not defined anywhere, but it's our contention that you have to look to Chapter 152 and the provisions of Chapter 152, and you also have to look to the terms and conditions of the centennial policy here. And when you look at both the provisions of Chapter 152 and the terms and conditions of the centennial policy, it is clear that the fund, when it paid a workers' comp claim, the claim to Ms. Poley here, was paying it on behalf of the insured Berkshire Bank.
So can I just ask you about that? What are we supposed to do with the terms of the insurance policy in a state where the terms of the insurance policy would have to comply in every respect with the legislation regarding workers' compensation, right? To the extent that the insurance policy diverts from that in any respect, no good.
Yes, Your Honor.
So it doesn't matter what the policy says. We look to the statute, right?
Understood, Justice Lank, but in response to that, this court recently, in its cases, has recognized that this is a standard form contract. In the HDH Corporations case, as well as in the more recent Great Northern case, this exact language, which contains both a duty to defend clause and an insuring agreement that has a duty to indemnify clause, it has been recognized that this is a standard form policy in Massachusetts, and the insurance commissioner has approved this policy form. And therefore, it is our position and our view that it does not conflict with Massachusetts law at all.
And does it add to Massachusetts law?
Does
Does it add things that are not in the statute?
I don't believe so, Your Honor.
Okay.
The problem, the difficulty we have with the Superior Court decision here is that it impermissibly carved out an entire class of claims from the ambit of the recoupment provision in the guarantee fund high net worth provisions.
Can I ask you, the fund is required to cover claims of insolvent insurers for various kinds of insurance, yes? And there are some exceptions. But workers' compensation once was an exception and no longer is. What does that do for your argument?
Yes, it actually supports our argument, Your Honor, and I'll try to explain that. If you look at the history of the guarantee fund, it's a very interesting history. In 1970, when it was enacted, it did not cover workers' compensation insurance at all, period. And then the guarantee fund, the legislature amended the guarantee fund in 1988, I believe, to include workers' compensation coverage for the first time. And then in 1993, the legislature amended the guarantee fund statute once again, and this time it was to remove the statutory cap that ordinarily exists for the guarantee fund
So that would mean
of
that
$300,000.
that would mean that the fund, I'm just trying to understand, that means that if there's a claim over that, the fund has to pay it on behalf of it. Is that what that means?
Well,
Not in this case, but just if there is a claim against an insolvent workers' comp insurer that exceeds $300,000, unlike other kinds of claims, the fund is responsible to pay that. Is that what that means?
With respect to workers' compensation claims, yes,
Yeah.
Justice Botsford. There isn't a cap that ordinarily applies to liability-type claims, general liability-type claims.
Thought that's
So-
what it was, but I just...
But the point I was trying to wind up and make about the legislative history of the Guarantee Fund Act is that when the legislature wants to treat workers' compensation differently, there's a long history of the legislature expressly excluding workers' comp or treating it differently. Here, when the high net worth amendment was passed, there was no carve-out for workers' compensation claims under workers' compensation policies. And the other point I would like to make is that under Chapter 175D, Section 2, the Guarantee Fund Act applies to all types of policies with certain exceptions, which are not relevant to this case. But the point is that the Guarantee Fund statute applies broadly to all kinds of policies for member insurers that write the coverage.
Let me
And
follow
here-
up. Can I follow up on that point?
Yes,
which
Justice
is,
Lang.
assuming that is, a straightforward reading, is there any other form of insurance other than this category of workers' compensation insurance for which the high worth insured provision has not been held to apply? Other than, let's take out the exceptions. All the stuff that's otherwise covered, let's just put aside workers' comp. Is there anything else?
I am not aware of any decisions in which the high net worth provisions have been held not to apply to policies that are covered by the Guarantee Fund Act.
Okay.
I am not aware of any decisions.
And I know Justice...
And I guess the other point I would add is under Section 2 of Chapter 175D, there are a litany of various types of coverages that are not covered by the Guarantee Fund Act, things like accident insurance and health insurance and warranties and things like that. But obviously, in this case, as I said before, if you look at the history of the Guarantee Fund Act, originally workers' comp was excluded, then it was added in 1988, then the cap was removed in 1993. But the point I'm trying to make overall is when the legislature wants to treat workers' compensation differently, it does so expressly. There's no mystery as to the legislature. And if I could talk a little bit about the Guarantee Fund and what it is supposed to do and what the legislative purpose, in our view, of this statute was.
Let me just, before you get there, let me just ask you one question. I think Judge Kaplan asked you about past practice and asked you to supplement, and I wasn't clear on the answer to that question as to whether or not this has been going on in the past and what prior interpretations have been about workers' comp in the statute.
Yeah, no excuse, because I'm supposed to know the record, but I was not counsel below, but I agree, that's my understanding of what occurred, that Justice Kaplan asked for supplemental briefing. And I think the specific issue that he asked supplemental briefing on was prior to 1988, when the workers' compensation was not covered under the Guarantee Fund Act. Could you come up with any examples of where an employer was basically held liable, that it had to pay a claim instead of making a claim against the receivership, the insolvent insurer? And the only example, from what I understand, that either party came up with, my brother, attorney Owen Gallagher, came up with the example of the Ideal Mutual case. So that's my understanding of that history. I would argue, again, once again, the Superior Court got it wrong. They were focused on, the Superior Court judge, Justice Kaplan, was focused on the wrong issue. What Justice Kaplan was focused on is there this continuing liability once the employer purchases a policy and that insurer goes belly up, becomes insolvent? And our position is that doesn't matter, because under Section 17(3), when a workers' comp insurer pays a claim, it is paying it on behalf of the insured. It's important to point out, and we point this out in our papers, that Berkshire Bank is the defined insured here under Chapter 152, Section 1(7), I believe. It is the insured party. That might be 1(6), my apologies. But it is defined as the insured party here. And the difficulty I have with my brother's position here is he's reading out whole classifications of policies from the ambit of the recoupment provision, right? He wants the recoupment provision to be limited to liability policies, to a subset of liability policies, because not only, in his view, is workers' compensation not covered by the recoupment provision in the net worth amendment, but his position is that it doesn't apply to things like no-fault insurance, a whole subset of what he describes in his brief as third-party beneficiary insurance. And this goes back to the question that Justice Lenk asked, which is, I am not aware of any decisions by any court, not just Massachusetts, where a court has parsed the net worth statute in such a fashion. And in order to get there, you have to read words into the statute that don't exist. There is no reference in Section 17(3) to liability claims. There's no reference at all to third party. It doesn't show up in Section 17(3) at all. So in order to get there, you have to add
to
words.
read statutes coherently and in relationship to each other. And so if we were to accept your interpretation of the statute, that would mean overlooking the workers' comp statute, which creates a certain relationship between the employer and the employee as far as workers' comp claims are concerned. I mean, you say if the legislature wants to do something differently, well, you know, I don't know how we're supposed to assume that in the statute the legislature intended to change that relationship without saying so.
Let me see if I can address you, Justice's concern, Justice Hines' concern on that. First of all, I think they can be harmonized, okay? I'm not asking this court to overlook Chapter 152. In fact, we rely on Chapter 152 to support our legal argument in this case. Our simple syllogism is that employers have legal liabilities to pay workers' compensation insurance. The way they do that is in three ways. They either purchase a policy, they join a self-insurance group, or they become qualified as a licensed self-insurer themselves, individually, okay? But there's no question that there's an obligation, and there are dire consequences if an employer does not comply, and I'm talking about Section 25A. So there is no conflict, and I'm not asking the court to do something to ignore Chapter 152. In fact, we argue that it supports our position, that by contract, when an insurer agrees to pay a claim, it is assuming that employer's liability, it is satisfying that liability, and it is discharging that liability. And therefore, when it pays a claim, it is paying it on behalf of the employer.
But if the
So we're not
employer
asking you to
never
ignore
has
it.
to pay, if the employer never is liable to the employee for workers' compensation, as long as they have bought that policy, I don't understand your argument. If that's what the statute, that's the relationship the statute creates. You're not doing it on behalf of somebody who doesn't have to do it in the first place.
Well, they do have to do it in the first place. That's my point, Your Honor, is that in the first place, there is a legal obligation, and that is being assumed and discharged by the insurer. And the insured is defined in this case as Berkshire Bank, and so the payment was made on behalf of the insured in discharging that legal liability. So I would disagree. It is being made on behalf of it. And there is no need to amend Chapter 152. I know the Superior Court went off in that direction, but there was no intent by the legislature to affect the rights of injured workers here. All the legislature was trying to do was to give the fund a right of recovery. And
But if you take Justice Lincoln...
I see that I am over time, but
If you take Justice, Mr. Chief Justice, if you take Justice Link's question and Justice Hines' question together, so the Model Act in this situation is based on direct liability states. And now you have this statute recognizing that Section 152 in its existence, and that we have 17.3 drafted, and shouldn't we just assume that the legislature, understanding on behalf of language, would have to apply not to the insurer, since the insurer is not directly liable to the employee? I think that's the synergistic effect of both of their questions, isn't it?
well, I guess I would disagree with the premise that the NEIC Model Act requires an ongoing obligation that you're suggesting. I don't think that was intended by the NEIC. I think the recoupment provision was meant to apply to workers' compensation claims based on the NEIC commentary that we cite in our brief. The NEIC said specifically, by liability, we're including workers' comp here. So that was the intent of the NEIC. I don't think the NEIC exhaustively looked at all 50 states when it was adopting the Model Act. I wouldn't suggest that.
Can I ask here, what is the employer's obligation under the Workers' Comp Act? Is it to pay workers' compensation benefits?
It is to
It is,
provide
and
for the...
because that's what the insurer is required to do.
it-
But I'm not sure that, is that what the Act provides for that the insurer's liability is for? Assuming that the insurer does not get an insurance policy, is that the insurer's obligation to pay workers' compensation benefits?
No, it's to
No,
cover.
but what happens if the employer does not get a policy at all? Is there a whole parade of horribles that can happen?
No, I understand, but, and including...
Fines and
including
penalties,
tort
criminal
liability.
fines and penalties, and
Tort
strict liability.
But that's the question. The employer is never liable to pay workers' compensation benefits.
No, I disagree with that premise as well. Under Section 25A, there is an obligation. There's an original obligation on behalf of the employer to do one of three things. Number one, either purchase a policy. Number two, join a self-insurance group. Or number three, to become a qualified licensed self-insurer. So
Right.
our
Those are
position is there is a statutory obligation to do one of those three things on behalf of the employer. So there is a liability or obligation originally with the employer
And you're
to do
saying the
this.
obligation is to pay workers' compensation benefits? No.
It is to provide for the payment of benefits, absolutely, in Section 25A. Absolutely. And they have three options. It's laid out in the statute, absolutely.
Okay,
I see my time is up. Thank you. We ask that this court reverse the Superior Court order and remand the case with an order to enter judgment in favor of the fund.
I just had one last, does the 25 million, is that one of these adjustable figures? Or does it stay at 25 million?
Well, I think that's up to the legislature
I
to
mean,
decide.
that's-
I mean, other states have higher numbers. You know, I've seen in some states where it's as high as $50 million.
No,
So
but it's set by the
it's
legislature?
set right now by the
okay.
legislature. It is.
So it's not inflation adjusted?
I don't believe so.
Okay. I mean, there
Well,
are
like the statutory cap, I'm sure it's revisited from
There's
time
some
to time.
statutes that say that some agency ups it, or, you know.
No, I'm not aware of that.
Okay, thank you.
Thank you.
Gallagher?
Good morning. Owen Gallagher with Gordon Prescott for Berkshire Bank. Tracking on the questions that were asked by the court, I'll try to answer some of them. And that is, I think you have to look at what Massachusetts has going back to the original statute, which is Chapter 751 of the Acts of 1911. At that time, a number of states began to implement workers' compensation plans. However, before the workers' compensation was in place, there was employer's liability. That also was statutory. We still have a vestige of that. That's Chapter 153. In setting up these different plans around the country, most states set up workers' compensation, modifying their employer's liability, basically taking their statute where the employer has some direct liability and saying, you can opt out of this direct liability and buy insurance and thereby satisfy your obligation to pay benefits. The example is between Rhode Island and Massachusetts. In Rhode Island, the statute, as we quote in our brief, has direct liability for the employer. And in fact, if a case goes into court, it goes into a special workers' compensation court where the parties are the employee against the employer. The employer buys liability insurance, which will indemnify that employer from their obligations under the Workers' Compensation Act in Rhode Island. Very similar to just a specialized court like any other court, where the insurance carrier has a duty to defend, duty to indemnify, but is not the primary party liable. Massachusetts, as it's wont to do, set up an entirely different, unique system. If you look at the original act, it set up an insurance company, the Massachusetts Employers Liability Insurance Company, which actually now is Liberty Mutual. And originally, it was going to be a single provider. The legislature was lobbied, and they changed it to make other liability insurers. But as you look at the act, the only parties are the insurance company and the employee.
Mr. Gallagher, an employee can satisfy the notice provision by notifying the employer of the injury, correct?
Correct.
Well, doesn't have to notify the insurer, right?
Oh, no, it doesn't. But I was saying that in the proceeding before, in the original act, and presently, the only parties are the insurance company and the employee. The notice requirement is statutory, simply being very liberal to make sure that there's no questions about any prejudice to the insurance company. They can notify either party. So in Massachusetts, what we have is an entirely different system, of which is direct liability, where the employer is only required to either buy insurance or to become a self-insured.
What do you say about the fact of the argument that when the legislature has historically with the fund, it has treated workers' comp very specifically. There's no mention of it, and why can't you read on behalf of in a somewhat broader view? Because clearly the liability to start with starts with the employer-employee relationship. There is an underlying, all of the workers' comp is an obligation of the employer to cover the injuries, work-related injuries of the employee.
I think it really depends upon what the relationship is. Historically, the employer had direct liability in Massachusetts. Now they do not. Their obligation is to, yes, cover the payment of benefits by purchasing from an insurance company those benefits, so that they buy a policy, and under the statute, they basically have an exemption from any liability back.
Now, we focus on the intent of the legislature. There's no rule of lenity applied here. Why would we interpret the legislative intent by including the words for, to, or on behalf of the insured to mean, oh, we're not going to include workers' comp, which may have potentially the greatest source of liability to the fund? I mean, it's a rather cute way to do it. Why should we infer that they would do it that way?
Well, the legislature is charged with the knowledge of what this court has said about
Yeah, but
workers'
we
comp.
know that They are no more omniscient than we are about every variation in the workers' comp law. I mean, why would they do that?
Well, I think there's a couple of reasons. One is workers' compensation liability is unlimited. For regular liability cases, such as a tort case involving a automobile or a slip and fall for a high net worth insured, there's a $300,000 cap. It's significant, but it's not millions of dollars. And so you're looking at workers' compensation in which the legislature says, is this really a good idea, hypothesizing, to have unlimited liability on these insureds? Yes, there's insurers like banks, but there are other smaller companies where workers' compensation, unlimited liability, can run into 7 figures very easily.
It's a fair point, but if the legislature thought that, why would they not simply say, this does not apply to workers' comp?
Because it was already in place that there was, they had to add workers' comp because it was being treated as a different type of coverage. Because it's, as I say, it's this third-party beneficiary coverage, no different than if I bought health insurance for my employees and the health insurance company went bankrupt. I'm not liable to my employees for the
No,
health
but
insurance.
isn't health insurance specifically exempted from the fund?
Oh, no, I'm saying it's mandatory in Massachusetts, but it is, because there's actually a separate insolvency fund for health insurance and
Okay,
life
but-
insurance. And it does not have
But the
a high
question
net-
is, I mean, if the legislature says we wish to exclude workers' comp from the obligation for high net worth entities, why not just say so? Why do it by saying, oh, we're going to say to or on behalf of the insured, and because our workers' comp statute provides for direct liability, the consequence of that is to exclude workers' comp and possibly exclude other sources of insurance.
Possibly. I mean, the other liability insurance we never argued is out of the high net worth insurers. That's the automobile insurance or liability insurance. That's in the appendix.
Okay, so I'm sorry, so you're saying that there's now ambiguity as to which,
No,
as to
I don't.
what the scope is of this language in terms of which types of insurance are excluded?
No, I say that,
Yes, you do, because you have all these carve-outs. You say it only applies to third-party beneficiaries, things.
no, I'm saying, excuse me, the third-party beneficiary examples in my brief and in the lower court appendix were all based upon, other than, if you go back to the appendix, we specifically stated, we're not arguing that third-party liability for automobile-type torts or for slip and falls or any type of commercial insurance, other than workers' compensation, is outside of the Section 17(3).
Don't you suggest
But
no
the-
fault is outside of it?
No, but no fault is a very limited provision. I do. I say that it's because that's you're buying it for a third party. You're not, no fault insurance for a high net worth insured, they would not recover because that could be considered as first-party insurance.
And that's the consequence purely of the inclusion of the phrase "to or on behalf of the insured"?
I think it's also based upon the defense or indemnity or otherwise, because the conditions they've put in are very specific. They've put in on behalf of us, on behalf of a third high net worth insured, for defense and indemnity, or indemnity, excuse me.
So-
And so that you're talking about, pardon me, you're talking about several conditions.
Can I ask something that I don't understand? I mean, it seems to me that the fund's essential argument is that if we're required to cover, if we're on the hook for covering claims for belly-up insurers, then we have the right to somehow get compensated for this, or we have the ability to raise funds to do this. One of the ways to raise funds, of course, is to make assessments against solvent insurers. One of the other ways, of course, is to collect it from high net worth insureds. Are you saying that as to workers' compensation insurance, the fund is on the hook to pay it, but also doesn't have the ability to assess solvent insurers?
No.
Why not? What's the difference then?
Because
What's the difference between the way of being able to get money back into the fund from the high worth insured's provision and the other ways of doing it?
Well, the other way that they recover it is if there was a shortfall, there would be an assessment against the insurers up to 2% of their premium for that given year.
That's everybody, right?
That's everybody. But also, let me go back, Your Honor. The fund also has, because of the statutory changes in 1991, because of the American Mutual case, insolvency, they have the same priority claim as a level Class 2 claimant in the insolvency, as does the workman's comp, the employee. When they changed the law, they gave the fund that same priority for workers' compensation. So in the insolvency, the fund goes to the top of the list for workers' compensation claims, so that there's a substantial recovery from the insolvent estate because of that, additional to the assessments.
And your point is what? I'm not
Well,
understanding it.
that they basically have another source of income that comes back into them because of their priority claims in the insolvent estate.
You're saying the one form of the recoupment they're not permitted is the high net worth insureds.
Well, I'm saying that the statute is presently written. If the legislature was clearer in its statement, they could. I'm not saying they couldn't. I'm saying because this is a workers' compensation issue, that the workers' compensation statute and the way it applies and the way they wrote the statute, workers' compensation is not in the...
Why would they do that? Put the on behalf of language aside for a moment.
I think in the
Why
brief-
would they allow recourse against high net worth insurance and say, but high net worth workers' comp is excluded? It's a matter of policy. Just put the on behalf language aside. It doesn't make any sense.
Well, I tried to make some sense by stating that, in fact, you have unlimited liability for workers' compensation, which you do not have for the other types of policies.
But why, wouldn't, to that point, if the legislature, in fact, dropped the cap for workers' comp for the fund's obligations, right?
Mm-hmm.
Wouldn't it make sense that the legislature would have some interest in allowing the fund to recoup some of that?
Workers' compensation has always been treated differently in Massachusetts, and that's one of the reasons it was never originally in the insolvency fund. So that I really can't answer what the legislature intended, but all I can say is this is what they wrote, this is how the statute is set up, and this is what the consequences are. This is not a statute, by the way, that has a provision, as others sometimes do, that this should be liberally construed to affect the purpose. This is just a statute that is interpreted under the standard methods of interpretation. The legislature wrote the language. We say it's unambiguous. The fund says it's unambiguous. And this is what it says.
You both think it means something else.
Pardon?
It's unambiguous, but it means something else for the two of you.
We argue that it means something else, the two of
Right.
us do.
So it's so clear.
Yeah. No, just also to the question that was earlier asked, I had a note, and that was in the appendix, there is, in fact, the materials from the Ideal Mutual case, and that was what Judge Kaplan had asked for, and we submitted affidavits and materials from the single justice, where it showed that, in fact, there had been a case in which the claimant had been on workers' compensation, was paid in the insolvency by the receiver, who was an associate commissioner of the Division of Insurance. And ultimately, it came to the point where the bond was exhausted. And what they did is they basically went to the Workers' Compensation Board and settled the case for a limited amount, stating that it was worth much more, but there was no more money available, and that there would be no other payments. The employer in that case was the city of Chicopee. There was absolutely no question that they could make the payments if they were legally obligated to do. And that was one of the issues that Judge Kaplan
But
raised.
Mr. Gallagher, that was before the statute required the fund to ante up, right?
Yes, Your Honor, it was. It was 1984. This was
Yeah.
1988.
Yeah.
It was his example of trying to find out
Right.
what was being done before. What was the employer liable in any way, shape, or form.
Well, Mr. Gallagher, you've dealt with legislative history in your brief. Was there any specific legislative history about the language "on behalf of"?
No, it's very limited. We have all of the papers in the
Wasn't
appendix.
added at a certain time, or nothing like that that you could find?
Nothing, Your Honor.
Okay.
Okay, thank you.
Thank you very much.